And so the next panel is going to be talking about a project that the idea was to come up with some things that people might want to either replicate or pursue in their own regions. And Mike, if you're there, I'm going to let you take over to introduce this group and get the discussion going.
Yeah, thanks, Dave, and good morning, everybody. So yeah, this panel is going to be talking about censorship by PIO, Public Information Officer. And the idea here is governments have increasingly imposed gag rules on their employees that not only silences the employees, but prevents their expertise, their information from inside the government from getting out to the public. So we're going to talk about the problem and what we as clinics could do to start to address that. And on this panel, we have Kathryn Foxhall, who's worked for more than 10 years to rectify this issue with, she works with the Society of Professional Journalists, where she's a member of the Freedom of Information Committee. She's also reported on federal agencies for more than 40 years, so she's witnessed firsthand the increasing controls on reporting and the speech of government employees. We also have Frank Lamonti, who's the director of the Breckner Center for Freedom of Information at the College of Journalism and Communications at the University of Florida. Previously, he was executive director of the Student Press Law Center. And we have Greg Leslie, the executive director of the First Amendment Clinic at the Sandra Day O'Connor College of Law at Arizona State University. And he's also a professor of practice at ASU's Walter Cronkite School of Journalism. He was previously a staff attorney with the Reporters Committee. So, and also I am Mike Lindhorst. I'm a fellow at the Media Freedom and Information Access Clinic here at Yale. And we've done a little work in this area, which I can talk about soon. But I'd like to start first with Kathryn to talk about the problem and how she's encountered it and what we're facing here. You're muted, Kathryn.
Michael, do we have about 10 minutes each or what?
Yeah.
Okay. As Michael said, I was a reporter basically on federal health agencies for 40 years. So I actually experienced and was deeply privileged to report on public health before this started happening. And I have been in like astonishment for close to 20 years to where that any of us would want to live in a society that is doing this. For example, during the early years of AIDS, just another horrible, dark crisis, we picked up the phone and talked to people, talked to experts at CDC. That's everybody did it, big, small outlets, whatever. And just as a part of your reporting know-how, you knew that the official story was the facade. And you couldn't possibly just take that and run with it. It was not real. And you could get, if you could get 5 minutes on the phone with an expert, you suddenly know why it wasn't real. I date these controls on the federal level from about 1993. But they just got worse and worse and worse and tighter and tighter. It's hard for me to say how catastrophic this thing is because, for instance, CDC is our structure, is our main lead structure in preventing pandemics. And we don't know who the hell they are. I mean, you can't, even after you go through the censorship office, they often just don't let you talk to anybody. no casual conversations. I mean, that's written policy in HHS. I would say that contact, just by contact, it's down by 90%, if not 99%. And we're going to be facing pandemics, climate change, and here we are not knowing who these people are, not having a good sense at all. Okay, so major issue. Why isn't the news media focusing on this? I have several theories. One, we have a long and deep history of just saying a good reporter gets the story anyway. So basically, we believe, the psychologist Daniel Kahneman says there's a human bias to believe what we see is what there is. I think it's worse with journalists because we work for what we get, and we believe what we get is what there is. We do not want to think. Something inside us keeps us from thinking there's somebody in that agency that could blow our story back to molecules. So as a result, now we're in the public health crisis of the century, and there are 11,000 employees at the Centers for Disease Control, the lead infectious disease agency for the world, and they are in essence silenced. You can't get to them, you can't approach them. It's a horrible chokehold on it, and most of the time we just don't get to them, with some nice exceptions. We tend to believe that what we get is what there is, and we don't. So I think reporters in big and small, I've heard several New York Times reporters and Washington Post reporters talk about this. We're frustrated, but we really don't want to face the fact that this is impacting in a catastrophic way the reporting. Now that we're in the pandemic, we're getting some background on how underfunded and vulnerable CDC has been for some time. This is immoral that we didn't know, and I think it has resulted a few million more lives than would have otherwise happened. I had that experience with AIDS. You get the official story, and then you get the behind the scenes story from experts, and you're just shaken because you realize you could have gone with that official story, and it was just slimy in what it didn't say, because they are very much under a political structure.
So Kathryn,
Okay.
I wonder if I could just jump in and turn to Frank for a moment about what we can do to try to get that information out there, right? So the information you mentioned about CDC not having the funding, CDC experts not being able to talk to the public, why, from a legal perspective, why can't they, and how might we go in and intervene?
Thank you, Michael. Yeah, if you don't mind, because you can't give a professor a microphone without getting a PowerPoint. So I'm going to show a couple of visuals here. Just by way of introduction, because I'm not sure we're yet world famous, Brechner Center exists in an interesting niche that kind of supplements and complements the work of some of the people we've been hearing from this morning. Unlike a lot of the other legal clinics, we are not built to litigate. We are built specifically to do research. And research focusing on kind of the 99%ers of journalism, the people outside of the Beltway who are doing that community journalism and running up against exactly the kind of obstacles that Kathryn has described so well here. When I first started this job, I asked my friends in newsrooms and representing journalists, what were your pain points? What were the most habitual obstacles that you ran up against that were preventing you from getting the information that your audience needs? And to a person, they came back and said, no one that we cover is allowed to speak to us. Everyone is terrified of speaking because they've been told that it's a firing offense to turn up in the news without getting a supervisor's approval. There we go. I'm actually going to, Michael, I'm going to hang on to the Chester County one, and you may address this in a minute. So I'm going to skip ahead to Dave Coulier dropped in the chat a link to where the SPJ has their research on this subject, which was done by Professor Carolyn Carlson, which is terrifically comprehensive research looking at the experience of journalists around the country running up against these, what we call gag orders, gag rules that say no one at the agency is allowed to speak to the press or public without prior approval. Those covering the federal government run up against it most frequently, but it applies at all levels of government, people covering schools, people covering police, people covering health agencies. What Carolyn found was that, oh, there we go, I'm sorry. Yeah, there we go. What she found is that journalists widely reported that they were prevented from talking to the employees that they needed to reach without the gatekeeping of a public relations officer, who often would end up either diverting the interview to somebody else, not the subject matter expert with firsthand knowledge, but somebody handpicked by the public relations officer, or just simply providing a canned statement. And what that resulted in was, you know, these very kind of antiseptic stories that lacked the firsthand knowledge of that police officer, that firefighter, that school teacher, that public health nurse on the front lines. And you've really seen this amplified during coronavirus, when so many times people on those front lines working in those hospitals will tell journalists, I'm sorry, I'd like to talk about the fact that we have inadequate PPE here, or we have an adequate bed space here, but I've been told that if I turn up in the news, I'll get fired. So this is really coloring and affecting the ability to tell stories. Claire Noren's team at the UGA First Amendment Clinic, which does great work down there, actually took some of the research that Breckner did and applied it to their own state in Georgia, looking at what state level agencies do. And what they found readily, just by looking at published policies of their state agencies and doing some FOIA work, was that at least a dozen of them had in place what could be characterized as a hard gag, meaning that no one at the agency could speak publicly without prior approval. And as you'll see, this includes some of the biggest and most important agencies of state government: the Department of Education, the public health agencies, corrections, the Public Service Commission that regulates utilities. All these places have hard gags in place telling employees that they can't say anything to the press or public about their work without prior approval. So knowing that these gags are out there, that they're pervasive, that they're interfering with journalists' ability to do their jobs, our team set out to figure out, was there a legal workaround to this? Was there a way to push back? And to our great and pleasant surprise, the answer is yes, that overwhelmingly, unanimously, when news organizations or when public employees or unions bring these cases under the First Amendment, saying that these gag rules are unconstitutionally overbroad, they win every time. There are at least 24 documented court cases on the books saying that government agencies cannot enforce the exact kinds of policies that Claire Norens and her team found pervasive throughout the state of Georgia. I'll talk more about some research that we have coming out shortly about police agencies around the country. But you see examples of the kinds of policies that are on the books that federal courts have said are unconstitutionally overbroad and can't be enforced. A policy like don't make official comments about department policy without prior approval. All these policies have been struck down under the doctrine of overbreadth under the First Amendment or the Due Process Clause, and yet they persist, and yet they're pervasive. there are 3 circuit courts that have actually said directly, including perhaps surprisingly the Fifth Circuit, not anybody's idea of where you'd want to initiate a First Amendment challenge, but the Fifth, the Second, and the Ninth all have binding precedent on the book saying that you cannot enforce a blanket prohibition on employees speaking to the news media without permission. The Moonen case is the most recent one. And that one was even a relatively narrowly tailored policy. It didn't say don't speak at all. It said don't speak about a particularly sensitive subject. For some reason, the police dog policy in that agency was controversial. And they had a specific targeted policy saying nobody say anything about the police dogs. And even that, the Ninth Circuit said, was an overly broad and unjustifiable prior restraint on speech. And so these policies do not do well when they are challenged in court. There we go, sorry, yeah. Why is this? What's the legal basis? How do you go about bringing a challenge? Well, everybody knows that the Supreme Court has sort of had a pendulum swing on the rights of public employees. And because this is a very knowledgeable audience, I'm not going to do sort of employment law 101 here, but I at least want to flag this much because I think there is a widespread perception, including among the government agency lawyers, that the Garcetti case in 2006, which denuded public employees of a lot of their First Amendment protections, that the Garcetti case somehow unleashed these gag policies and made it lawful to gag your employees from speaking to the media. But Garcetti said no such thing. We still have on the books the National Treasury employees case, and that's the signature case. That's a case that's about a blanket prior restraint on an entire category of employees. And the courts have made a distinction between Treasury employee speech on the one hand versus Pickering-Garcetti speech on the other hand. Pickering-Garcetti analysis will apply when it's an individual employee that is disciplined for an individual content-based incident, like I ran my mouth about something that was confidential that I wasn't authorized to talk about. That's the kind of speech that gets analyzed under the Pickering-Garcetti framework. But when you have a facial challenge to a blanket prohibition on speaking, that gets analyzed under a different framework, the framework set forth by the Supreme Court in the Treasury employees case, which is a very rigorous First Amendment standard that is hard for an agency to overcome. Treasury employees was about a federal ban on accepting honorarium for speaking. Again, not even a categorical blanket gag. And even there, the Supreme Court said, no, that is an undue and unjustifiable prior restraint on employee speech, and you cannot enforce it. Garcetti said nothing about Treasury employees, did not disturb that analysis. And I showed you the Moonen case. The Moonen case and a couple of district court cases post-Garcetti has specifically and explicitly said Garcetti does not disturb the more rigorous Treasury employees analysis that applies to a prior restraint on speech. So you still have the benefit of the skeptical scrutiny that a prior restraint will get if you challenge one of these. I mentioned a new paper that we have coming out. This will probably be out by the end of next month in the Akron Law Review to follow up on a paper, and I'll drop some of these links in the chat. We did a paper back in 2019 that was published in Kansas Law Review looking at the problem writ large at the national level. But because we knew that law enforcement agencies were especially prone to gag their employees, and right now there's no government agency that people are more interested in than the workings of police departments, we wanted to see what are law enforcement agencies doing. So we pulled the policies. We FOIA'd the 100 biggest law enforcement agencies in America, and we got back 77 out of 100, and you'll see the results. What we found was that 77% of those policies that we looked at, over 3/4 of them had language that was either clearly unconstitutional under the prevailing standards that we talked about, or that at least existed in a constitutional gray area. For example, there are policies that will say, don't address sensitive or controversial issues without pre-approval. That's like the Austin policy. And so it's not a blanket prohibition, it's not a blanket gag, but it still, I think, is vulnerable to challenge. And then we did find that about 1/4 of the policies, including some really big ones like Chicago and Philadelphia, on paper looked just fine. On paper looked like they aligned perfectly with the Treasury employee standard and with the cases interpreting it. But we also know that, and Kathryn has alluded to this, that the on-the-ground practice may be very different than what the law says. The on-the-ground practice in Chicago, for instance, if you look at news coverage of the Chicago PD, invariably you will see somebody from the police department say, "I'm sorry, we can't talk to you. It's my understanding of the policy that we're all forbidden from speaking." So there is a water cooler policy that may override the legally defensible one that exists on paper. Really quick, because I know that I need to wrap up and pass the mic to Greg, but this is a little bonus one for you if you're interested in taking on these media gigs. They are also illegal in the private sector. They are also illegal anywhere that the National Labor Relations Act applies. And the First Circuit just said so in a case called Maine Coast Regional Hospital. Maine Coast Regional Hospital was about one of these media gag policies in an NLRA regulated healthcare agency, a hospital chain. The NLRA applies only to the private sector, whereas the First Amendment applies only to the public sector. But interestingly, the NLRB has said, we regard the protection of the NLRA to also outlaw these blanket gag policies against speaking to the media because they impede the ability of people to blow the whistle on unsafe or unsound working conditions, and they inhibit people from being able to reach out and build the alliances that they need to change working conditions. I have the Elon Musk infamous tweet here about trying to discourage unionization at Tesla. Elon Musk was the latest to be told, you also at Tesla cannot enforce one of these blanket media gag policies, and he is now appealing that. That case is in front of the Fifth Circuit right now, so that's one to really watch because the Fifth Circuit has a chance to fall in line with the consensus of the other courts and to say that private sector employees like Tesla also cannot enforce these gag orders. So I'm going to stop there and encourage Michael and Greg to sort of, now that I've told you how easy it is to win these cases, Michael and Greg can tell you how hard it is to win them.
Yeah, so Greg, I know you guys have targeted one of these policies in Arizona. Could you talk a little about your work there?
Well, I wish it were that simple. We haven't really targeted it yet because we've got an unusual situation. Basically, a journalist we've been working with for years at an NPR station here wanted to interview some prisoners and was told, well, I can't arrange that interview. And this was about a year ago now, said I can't arrange that interview, not because of COVID restrictions, but because of the new prison interview, the prison's media relations policy. And so he was given a copy of this new policy that he hadn't seen and saw that the right to interview prisoners was fairly gutted. There were no longer any provisions for in-person interviews. And so then he looked at the rest of the policy to figure out what else had changed. And there used to be a great paragraph in there saying that employees, of course, can talk to the media on their own time. If they want to do it on prison grounds, they have to have permission. That was just eliminated. So we're dealing with an anti-policy. Like there used to be a good policy saying you have the right to do this, which wasn't any great grant of a right. It's just obviously stating the law that if you're talking in your personal capacity outside of work hours, off of state property, you can talk to the media. So they just completely removed that. So leaving in place a prohibition on speaking to the media on behalf of the prison system. So that's going to be much more defensible to say that the particular prison guards, prison employees can't speak to the media just on their own, on behalf, looking like they're speaking on behalf of the prison system. So we're starting with this unusual situation where we don't have a policy directly to challenge. We're kind of challenging a negative. We're challenging the removal of a certain protection. And to give a little context to this, everything kind of changed when a new prisons director came on board. The part regarding prison interview of prisoners is influenced by the fact that apparently 2 out of 3 prison interview requests in Arizona are to interview Jodi Arias, who was the subject of a sensational murder trial 10 years ago, where she had allegedly, she's convicted of murdering her boyfriend. And then on the flip side, the issue of having prison guards talk to the media was directly related to the fact that a prison guard came forward as a whistleblower and said, look, the state is not maintaining these prisons. Every prison has a number of instances where doors are not locking correctly and prison guards have been assaulted. And she felt it was her duty to come forward and say, we have to do more in this state to protect the prison guards or to maintain the prisons. So a new director, and that actually led to the old director resigning. The new director's first response was to issue a new policy, absolutely saying that you do, removing this provision, saying that you, of course, can speak to the media in your personal capacity. And just to get to the details, the section, the paragraph in the policy said, any department employee may speak with the media about personal issues or to express their personal opinions about department operations in general on their own time. Whenever a department employee has contact with the media, the employee is expected to demonstrate professionalism in demeanor and dress codes standards. No interviews may be conducted on state property without express prior approval of the media relations administrator. So it was a policy that actually said you can comment on your personal opinions. You can express your personal opinions about department operations. It was something that was great for whistleblowers. It was great for journalists who wanted to say, hey, how's it going? How do you feel the department is protecting you? How are they doing on maintaining these prisons? And it was specifically gutted because of that incident. It's an incredible process. So we're facing that negative where we don't have a policy that we can directly facially challenge. We have the absence of a policy. So our decision was to find out more about how this was enacted, behind the scenes. So we filed a Public Records Act request seeking all communications about the change to the policy. And we got a number of documents pretty quickly showing that the approvals, the changes were approved through different offices, almost in a rubber stamping kind of system. There was no real conversation about the changes. And then for months, the department kept telling us, well, we've got more information, but it's going through the redaction process. We'll get back to you soon. And that took about 9 months. And that brings us to this week. We literally just on Wednesday got a document dump of about 500 pages related to the changes of the policy. And it looks like the only redactions so far have been telephone numbers when people are saying, hey, call me about this policy, employees talking to other employees. So we haven't found, I've been at the MLRC conference. We haven't gotten together as a clinic yet and gone through these documents. So far from a quick scanning, it looks like there is no smoking gun saying, let's stop these employees from talking to the media. Let's stop these whistleblowers. But there is good information showing that they've just got the most haphazard way of changing their policies. Unfortunately, we can't go to court and say they violated the State Administrative Procedures Act because the Department of Corrections is specifically exempt, is the only agency specifically exempt from the Administrative Procedures Act. And I haven't looked into that in depth yet, but apparently years ago, there was some problem where prisoners were challenging a lot of the rules related to how the department operates. And so again, the Arizona solution is to exempt prisons from having to follow the Administrative Procedures Act. So we're back to the point where we're really considering now whether, how to pursue this, whether we immediately run to court or whether we try to work with the department, knowing that they're opposed to this. But the other issue in a case like this is to figure out if you want to do it by representing the media as a client, or if you want to actually try to get some of the prison guards who want to speak out. And of course, very few prison guards would want to actually be involved in this litigation to say their rights to be whistleblowers have been jeopardized. So the positive thing, though, is that the association that works with, that governs the membership organization, basically, of the prison employees, was outraged when they heard about this policy. And again, to go over what happened with the reporter, he found out about the policy regarding interviews. That led him to find that this paragraph had been removed. So he did a story on the fact that these protections have been removed. That was the first time anyone in the Prison Guard Association had heard about it. So this was definitely done, silently, without any input, and outraged them. They were saying that we're going to look into this. That's unconstitutional. It shouldn't stand. That might have been too quick of a judgment on the question, but it suggested that they wanted to do more. So we had tried to work with them for a while, but just did not get positive responses, partly because, of course, in the midst of the COVID crisis, it was always harder to get people to return your calls when they were at government agencies, especially related to prisons, where, of course, there were even heightened, even greater COVID concerns than a lot of offices have to deal with. So we do feel that we're lucky that in Arizona, and I'm not sure how common this is, around the country, but when we started to look into having journalists saying, well, this affects our right basically to receive information, or our right to do news gathering, so we should have standing to pursue this case. There is good case law in Arizona saying, yes, individuals can pursue either the First Amendment rights of somebody they want to talk to, or just pursue the rights on their own. So and oddly enough, it does this without mentioning what I've always talked about as the willing speaker doctrine. That's as Frank's excellent law review article points out, that there's this doctrine out there of people being able to sue. Well, the whole history of journalists challenging gag orders in court really comes from that same thing, where a journalist has to have standing to challenge the gag order if they're not the ones gagged, if they're challenging a gag order on trial participants. And so the doctrine for standing that I've always worked with was the willing speaker doctrine, which said that if you can identify a willing speaker that you can now no longer talk to, then you've got standing. The Arizona cases don't even go that far. They just say if your First Amendment rights are significantly affected by the fact that you cannot speak to these employees, or speak to these other parties, you can sue for your First Amendment violation, or your speech under the state constitution, mainly, your right to speak to these employees and individuals. So we've got a good standard here, but this has taken a while to move forward. And the way these things often work, every time you plug one hole, another appears. So we had permission to proceed with this from the NPR station that our client works for. Now, as we've gotten better responses from the department, our client has jumped to another organization represented by other counsel. So we've got another knot to untie here in figuring out really who our plaintiff is going to be, what attorneys we're going to be working with. But we're making progress, and we've I think most people on this call know this, but when you've got a challenging thing like this, where you're not sure how this policy came about, you're not really sure about the implications, you can do some open records work first to try to get to the heart of how this came about and see if you can, uncover that smoking gun that just gives you the perfect excuse to go to a judge and say, look, they did this for improper reasons. So, that's basically where we are now. We've been kind of hacking away at it, and I think we've got a decent position, but we're not exactly to the point of filing anything yet.
Yeah, thanks, Greg. And talking about that smoking gun, here at Mafia, we've been looking for a policy to challenge. And I think we actually found a great one in Chester County, Pennsylvania, which is a large suburban county right outside Philadelphia. They created this policy, I think at the end of 2020, that prohibits any county employee from telling anyone outside county government any information they learn on the job. So this incredibly broad policy that initially said specifically, this includes not telling any information you learn on the job to any friends, family, or the press. So, I think like a dream policy in terms of targeting one of these gag rules. They later amended the policy to remove the part about friends, family, or the press, but then they kept the rest of the policy saying anything you learn on the job is confidential and can't be disclosed to anyone outside county government. The problem we ran into in looking to challenge this was, and actually one other juicy bit of background on this. They passed the policy a couple months after the Philadelphia Inquirer ran the story showing that the county's COVID testing was inadequate. I think the tests weren't working correctly. And that article relied on disclosures from unnamed county employees. So soon after the Inquirer wrote that article, the county passes this policy prohibiting employees from saying anything to anyone outside county government. So here at the clinic, we were excited about challenging this policy. Clearly violated the First Amendment rights of both the county employees and also reporters and anyone else who are trying to gather the news and talk to employees about what they're experiencing. The problem we ran into was actually finding a client, finding a reporter or news organization that was hurt by this policy, because it turns out basically no one is covering Chester County on a regular basis. There were a few Philadelphia reporters who cover the county every once in a while, but don't really try to interview county employees all that much. We couldn't find anyone who was actually harmed by this policy because they were trying to interview county employees and finding that they weren't able to. Also, no one who had definite plans in the future to cover the county, which was, I think, really a sad result of the cutbacks in local journalism, especially in these sorts of suburban counties that aren't at the center of a large urban area. So that's where we're at the clinic right now with, this policy that seems ripe for challenge, but nobody out there who can challenge it. So I'd like to turn back to Frank for a second and talk about, if a clinic has found a policy that seems unconstitutional, and the clinic's trying to figure out, how do we go about challenging this? Who's the right party? Who's the right client? What kinds of things are you looking for to establish standing and to bring this kind of claim?
Yeah, thanks, Michael. And I think that's very right. And of course, I think all of us who've litigated have a little bit of an ick factor associated with anything that looks like ambulance chasing too much, like please be my client, please be my plaintiff. And so there is a point at which if the policy is a tree falling in the forest and it's not hitting any journalists, then it doesn't even exist at all. And I think, unfortunately, we may have that situation. I pointed to the excellent survey that the UGA did about state government policies, but my gosh, there's probably half a dozen people in the entire state of Georgia who cover state government as a full-time undertaking anymore. And so to find somebody who's aggrieved enough to be able to stand on a witness stand or in a deposition and to say, yes, I would be able to speak to people on my beat, but for the existence of this policy, and I've had people tell me they would be willing to use Greg's terminology, they'd be willing to speak to me, but for the fact that they are forbidden by their employer from doing so. That's the dream case. You really want somebody to say, I have been affected by this in the future. And just like you said, Michael, I plan to cover this agency. I've been affected in the past. I plan to cover this agency in the future. That's the ideal person. If the ideal person doesn't exist, then I think it's at least conceivable that there could be some associational standing on the part of some combination of like a labor union and maybe like a society of professional journalists. I don't think that's ideal, obviously, because both you have to navigate then a second hurdle of associational standing. And also, I think it's a less compelling case for a judge, right? A judge is going to want to have a concrete controversy and to say, well, look, SPJ, are you bringing me an abstraction here? You'd like to see this policy off the books because you're a concerned do-gooder, or you'd like to see this policy off the books because it's actually afflicting your members in a concrete, demonstrable way. And so I think that's really what it's going to take. And fortunately, the lawyers in this field do talk to each other. They go to things like we go to, and they exchange intel. And I don't think it's going to take too many suits before notice is served on people in this field that you better clean up your handbook or else you're going to be sued too. So that's the good news. Can I talk for a sec about something that Tom Leatherbury dropped in the chat that we should probably not adjourn without talking about, because it does touch directly on this, which is the Wilson Houston Community College case that the Supreme Court accepted cert on. This is a real sleeper First Amendment case. It hasn't gotten any attention at all. We actually have a piece, because we don't sleep at Breitner, we have a piece coming out in the Notre Dame Journal of Law and Ethics in a couple of weeks that is about this case and flagging that this is one of those cases that I don't see any conceivable outcome that doesn't have a downside for the First Amendment, no matter how it comes out, unfortunately. And the underpinnings of this, and Tom, jump in if you want to address it as well. There's a kind of a gadfly who gets elected to this board of trustees of Houston Community College and sets about sort of destroying it from the inside. He files lawsuits. He gets a PI to surveil one of his colleagues. He's a bull in a china shop. And they finally sanction him for his conduct. They adopt a resolution censuring him and also taking away certain benefits of the office. And he sues under the First Amendment. Well, the case law up until that point had been unanimous that when a board does nothing but sort of just slapping on the wrist one of its fellow members, that's impervious to First Amendment scrutiny, not really on any First Amendment doctrinal grounds, but just sort of almost like a separation of powers thing, that when we let these elected officials control their own internal affairs and we defer to them. And there are even some courts that will say that act of sanctioning is itself First Amendment counter speech protected by the First Amendment, which I doubt, but the Wilson case comes out differently. The Fifth Circuit, in a deeply split decision that generated an attempt to go in bank, and they deeply split the circuit on refusal to take it in bank, says yes, Wilson has a First Amendment claim based on being censured because he's engaging in political speech, highest degree of First Amendment protection. He's been deterred from doing so. All the ingredients of a First Amendment case, he's got a trial claim. Now we're in front of the Supreme Court to resolve that circuit split. Do you or do you not forfeit the right not to be censured when you sign on for an elected office? Here are the First Amendment issues that I see. On the First Amendment free speech side, there are many policies, and Heather and I from Cornell have been chit-chatting on the side here during this conversation because she's got one up there apparently. There are a number of government agencies that have these don't talk to the media gag policies. that even apply to elected officials, county commissioners, school board members, college trustees. No one on the board is allowed to speak to the media, which seems like an especially noxious variant of the policies that we've been talking about. So if Wilson wins the case and wins a broad enough ruling, I think all those policies collapse like a house of cards. But if Wilson wins a broad enough ruling, we also cast a very dark and foreboding shadow over the enforceability of open meetings laws, which periodically have been challenged under the First Amendment because elected officials will say, I have a right to have an anonymous conversation with my colleagues about political matters without being forced to do so after giving notice and taking minutes and all the formalities of an Open Meetings Act. And if Wilson wins a broad enough ruling saying elected officials have the full benefit of First Amendment protection like any other citizen, period, full stop, the end, no Garcetti, we're going to see another wave of First Amendment challenges to open meeting statutes. So this is one that is really a prickly pear, and it would have been nice if the Supreme Court hadn't taken it. And I have no confidence in the outcome, but it's one to watch.
Yeah, that's really interesting. That'll be a good case to watch.
Yeah.
And Kathryn, we only have a couple minutes left, but I wanted to turn to you to ask, what SPJ and you individually have been doing to try to target all these policies, censoring government employees, and this long history of increasingly serious employee censorship.
Since about 2014, we have sent letters to all three of the presidential administrations. Tellingly, I think when we got over 50 organizations to sign on in 2015, we got a meeting with the Obama White House, which went nowhere, but it shows the strength of organizations coming together. I think that's one thing we've done. I think there's a lot of education when I hear you all talk about the problems of finding clients. There's a lot of education that needs to go on with journalists to say this fight is going forward, and not only is it going forward, but it's not good journalism to not fight this fight because things are being hidden from you with these barriers.
Yeah, so that's going to be another important task for maybe all of us, to spread the word that these barriers actually are not constitutional, and we can do something about it.
So our time is up. We run over just a little, but I want to thank the panel. This has been an enlightening discussion, and I think some of what I'm hearing, it sounds like it's a second order, effect of the lack of local journalism. It's almost like a cancer that's developing. These policies are being put in place, and no one cares. They shrug because no one's covering. And it's troubling. So I think this and the first panel kind of are hand in glove in a growing problem about our inability to get information about what's going on at the local level. So anyway, thank you very much. To the extent people need to take a quick bio break or fill their coffee cup, we have a really interesting panel on dealing with educating students on the First Amendment who may not be receptive to basic historic First Amendment principles. We're going to start that in about 4 minutes, so we'll be back then.